Welcome to Business Auto Focus on Liability Part 2. If you have any questions, please type them in the chat window. They will be answered as time allows or responded to after the webinar via email. If you experience any auto problems, please send us a note in the chat window or call our office at 800-741-4084. We'll attempt to correct the problems as soon as possible. In hour one, the previous session addressed the importance of making sure you list the correct name insured on the name insured line, finding out and listing the business whose assets the business auto policies are going to protect in item 2 of the deck. Any legal entity listed in item 1 will meet the definition of you in the coverage form: corporations, LLCs, partnerships, legal entities of the business. No need to list the owners, partners, managers of these legal entities in item 1 of the deck to protect them from owning, managing, overseeing the legal entity. Covered autos. To have the policy respond, the auto that was involved in the accident must meet the definition of covered auto or the policy will not respond. Those are the symbols we use. Keep these considerations in mind as we move forward with a review of the business auto coverage form. Auto liability coverage. We're looking at auto liability coverage provided by the business auto coverage form. Remember, this form is designed and used to provide protection to businesses who use autos as part of their business. The insurance agreement reads this way: Section 2, covered auto liability coverage. We will pay all sums an insured legally must pay as damage because of bodily injury or property damage to which this insurance applies, caused by an accident and resulting from the ownership, maintenance, or use of a covered auto. We will also pay all sums an insured legally must pay as covered pollution cost or expense to which this insurance applies, caused by an accident and resulting from the ownership, maintenance, and use of a covered auto. However, we will only pay for the covered pollution cost or expense if there is either bodily injury or property damage to which this insurance applies that is caused by the same accident. We have rights and duties to defend any insured against any suit asking for such damages or covered pollution cost or expense. However, we have no duty to defend any insured against a suit seeking damages for bodily injury, property damage, or a covered pollution cost or expense to which this insurance does not apply. We may investigate and settle any claim or suit, and we will consider appropriate as we consider appropriate. Our duty to defend or settle ends when the covered auto liability coverage limit of insurance has been exhausted by payment of a judgment or settlement. This is the over 3 paragraphs. Notice there are words in quotation. So let's look at every paragraph separately with the defined words. The insurance agreements for liability tells us what coverage will be provided if the policy responded. Paragraph 1, direct damage. That's bodily injury, property damage. Paragraph 2, covered pollution cost and expense. And paragraph 3, a duty to defend. So let's look at the direct damage. We'll pay all sums an insured. An insured starts with the legal entity listed in item 1 of the deck. In other words, the entity that you list or any legal entity you list in item 1 of the deck. Legally must pay its damage because of bodily injury or property damage. That's the bodily injury, property damage. That's the direct damage to which this insurance applies. It applies if it's not excluded. In section hour 3, we'll look at the exclusions. Resulting from ownership, maintenance, and use of a covered auto. Those are the symbols. If it's not a covered auto, then there's no coverage. So reading this for direct damage, if we don't style the insured properly, as we went through in hour 1, then the policy would not respond on the behalf of somebody being sued if we don't style the named insured properly on the item 1 of the deck. And second is, if the auto that caused the loss does not meet the definition of a covered auto, then there's no coverage. This is why it was so important in the hour 1 to go through these situations so that we make sure that the policy will respond by making sure we understand and list the insured properly and make sure that the autos the insured uses will be a covered auto and inform the insured how they will be a covered auto. The other definitions here, Section 4, which we find, or I find kind of funny, in that we start with Section 2 and we have quotation marks that tell us what these words mean, but we don't tell the public what the word, we don't tell the reader of the policy what the words mean until we go back to the back of the policy, Section 4. So we went to the back and bring them up here. Insured means any person or organization qualified as an insured in the who's insured provision, which we'll look at in a few minutes, of the appropriate coverage, except with respect to the limits of liability. The coverage afforded applies separately to each insured who is seeking coverage or against whom a claim or suit is brought. Bodily injury means bodily injury, hurting somebody, damaging their body, making them sick, or giving them a disease sustained by a person, including death resulting from any of these. Property damage means damage to or loss of use of a tangible property. This is sometimes misunderstood. We have two requirements here. Not only repair the damage we do to the property, but also pay for the loss of use of tangible property. So if our insured runs into a restaurant because they ran off the road, we would repair the restaurant building itself. But while the restaurant was shut down, because our insured ran off the highway and hit the restaurant, we'd also owe the restaurant the loss of use of that tangible property, meaning that's business interruption. Or more frequently, what we have is our insureds hit somebody's vehicle on the highway. We have to repair the vehicle that they hit, but at the same time, as that vehicle, the person who owns that vehicle that got hit, if our insured is legally liable, would also have a claim for us to replace that unit or compensate them for the loss of use of that unit. Don't have to rent one. We just owe them a compensation because they cannot use the tangible property when that's auto. So it's not only the damage and repair and replacement of what the property we damaged, but reimbursing the person who owned the property, if we're legally liable, for their inability to use the property. Accident includes continuous repeated exposures to the same conditions, resulting in bodily injury or property damage. Same definition we're going to see that you will find in the definition of occurrence later and when you study the GL policy. Auto. This is the big definition. Auto means a land motor vehicle, trailer, semi-trailer designed for travel on public roads or any other land motor vehicle that is subject to compulsory or financial responsibility laws or other motor vehicle insurance laws where it is licensed or primarily garaged. However, autos do not include mobile equipment. That paragraph B2 was added into the form in the revisions of the 2006 revision to match the change in the wording in the 2004 general liability policy. That was added where the vehicle that was subject to, land motor vehicle, that was subject to compulsory financial responsibility or insurance laws would now not be mobile equipment but would be an auto. This is also noticed there's no wheel requirement. It's any land motor vehicle where it has two wheels, a motorcycle, or 17 or 18 wheeler, which is the big tractor trailers we see on the highway, or even the doubles, which now have 20 wheels, or excuse me, 24 wheels possibly on those. So when we think of autos, we think of a motorcycle, we think of a moped, we think of a three-wheeler, we think of a passenger vehicle, private passenger, or we think of large tractor trailers with many wheels on the units. There's no wheel requirement. The only requirement is that it must be a land motor vehicle, meaning travel on the land, a trailer the vehicle is pulling, or a semi-trailer designed for travel on the public roads. But it also does not include mobile equipment unless the mobile equipment has to be licensed for the highway. We'll look at that in a few minutes. If the unit involved in the accident is mobile equipment, then the GL policy responds. If the unit matches the definition of auto, then the auto policy form responds as long as it is a covered auto. So the definition, going back again to Section 5 of the auto form, this is the same wording, the same definition you find in GL. There's no conflict here. The two policies work together by having the same definition of auto and having the same definition of mobile equipment in each. This is the definition of mobile equipment. bulldozers, farm equipment, forklifts, and other vehicles designed for use primarily off public roads, vehicles maintained for use solely on or next to premises you own, vehicles that travel on crawler tracks. When we look at what a business might use that has a commercial auto exposure, we understand bulldozers in all cases, most cases will have a crawler track. Forklifts are not usually running up and down the highway. They're off-road. But farm equipment can be a little different. In Florida, we have things called goats. These goats are in the farm fields. The goats are used to take the oranges, grapefruits, tangerines harvested by the pickers. They put them in the back of this unit, which is simply a one-ton truck with a flatbed on the back that has a hoist on it. They put the beds or the picked items of the bins in that. Then that unit is taken in the field, and those items are dumped into a trailer. That's farm equipment. That trailer then is transported off of the property to be taken to a processing plant. But the machinery, the goat, moves from field to field. And when they move field to field, they're on the highway. And therefore, they have to be licensed. So if you insure a farming risk, if you insure a harvester risk, then your concern is that goat, that harvesting item that has to move from field to field. Same concern that you have in potato harvesting. Also in the Midwest, we have the custom farmers and the large combines. Again, they're primarily used for the unit that is on the highway, on the field of hay, or excuse me, grain or corn or hay, and those items. These harvesting equipment then though move from field to field on the public roads, and depending on the jurisdiction in, they might or might not have to be licensed for the highway. Again, farm machinery would be a gray area where it would be mobile equipment versus auto. Vehicles maintained for use solely on or next to premises you own or rent. In the transportation industry that a lot of you all are members of because of the foundation focus on the motor carrier, those are the yard tractors. And some other things, though, you have things like you have the units that run around golf courses, you have the units that run around pits for large excavation companies. You have those kind of units maintained primarily maintained for use solely on or next to premises you own or rent. Two things about that: solely. Do they ever get off the highway? That's the problem here, because as long as they're on the premises, they're mobile equipment. But once they get off the premises and run from the highway, except for ones that are property next to each other, then it becomes an auto. By definition, goes now it has to be licensed for the road. It's also the premises your insured owns or rents. Had a situation where one of the members of the foundation called me up and said, my insured has a contract with a railroad to spot trailers off of the yard and put them on the piggyback arrangement on the flatbed trailers. That yard tractor that is spotting those trailers is an auto, because that premises that's being used on is not owned or rented by the insured. Where if they were doing on their own premises, then that auto would be mobile equipment unless it gets off the road for maintenance or filling up. So you have to be, not only does the unit ever get off the premise, but also is the premises it's being used on owned or rented by the insured. So that's the gray area, and that would be farm equipment. The next gray area will be vehicles, whether self-propelled or not, maintained primarily to provide mobile equipment that permanently mounted power cranes, shovels, loader, diggers, or drills. Power cranes, those are the heavy haulers. You have numbers of insureds that have flatbeds, and they have a crane operation. The crane operation runs down the highway going from job to unload the flatbed. You have sign companies that have separate cranes that are run down the highway. The signs are then carried on the flatbed to the to the location the signs are going to be installed in. That crane mainly is being used to load and unload those flatbeds. It's moved from location to location only so it can be used on the to load and unload the flatbeds once the flatbed gets there. Yet, while the power crane is on the highway, it would be an auto because in most jurisdictions they have to be licensed. Drill rigs also, water wells or oil wells. Some of that drilling operation, the workover rigs or the drill rigs themselves, are self-propelled, meaning that the drill rig is mounted to a chassis. The chassis can run down the highway carrying the drill rig. The drill rigs are used on locations. They might not move often depending on the time it takes to drill the well. But when they move from well site to well site, then they are on the highway and have to be licensed again. So if you're insured as a heavy hauler or you're insured in the drilling business, then the power cranes and the drill rig would also have to be considered an auto, and you'd have to walk through that with your insured and your insurer to properly cover that. Road construction, resurfacing, typically those are not wheeled, not confused by autos. The vehicles described above that are not self-propelled are maintained primarily to provide mobility to permanently attached things. Those are air compressor, those are the trailers, those are things that are being hauled. Obviously when they're attached to the power unit, that's where the exposure is. 6, vehicles not described in the paragraph above but maintained primarily for purposes other than transportation of personal cargo. However, self-propelled vehicles with the following types of equipment attached are not mobile equipment. Again, snow removal, road maintenance, street cleaning, cherry pickers and similar devices, or air compressor, pumps, generators, including spray rigs. So those are autos. And again, we'll talk about it later when we look at the coverage use of it. They the mainly purpose here is using on premises a very limited road exposure in most of these things. So we have to balance the auto and GL. So we have to worry about farm equipment, cranes, drill rigs, and the items listed here if your insured owns those items and using them in conjunction with the other commercial autos they use. Because here they are mobile equipment, however by definition under 6 they're considered auto, and by the definition of auto and also the definition that you find in the mobile equipment says, however, mobile equipment does not include land vehicles that are subject to compulsory or financial responsibility laws or other motor vehicle insurance laws where it is licensed or principally garaged. Land vehicles subject to a compulsory or financial responsibility laws or other motor vehicle insurance laws are considered autos. That's where the balance is. So the items in 6 are autos, yet there's very limited road exposure. And the items that with other mobile equipment, primarily in the areas of combining autos and things that look like autos but or really can be considered mobile equipment. The farm equipment we discussed, the cranes, the drill rigs, and the vehicles that are used on the insured premises to spot trailers or do maintenance on the premises would be a gray area where if they only work on the premises, if they never leave and get on the highway, they'd be mobile equipment. But once they're on the highway, they have to be licensed for the road and meet compulsory financial responsibility laws. So therefore, now they're going to be an auto, not mobile equipment. And the other problem here is where it's principally garaged. So you might have a situation, particularly in the Midwest, where that combine we're talking about is going from field to field to harvest hay. In one state, it might be considered not required to have financial responsibility laws or be licensed, where another state it would. So it could even vary by state. So it's very important. You got to review the mobile equipment. If your insured has any of these kind of equipment, they're contractors, they're farmers, they're heavy haulers, they are pump out, they have drill rigs, those things. If licensed or should be, then it must be addressed for auto liability in the auto form. Concern, if not licensed, should have been. That's a concern. If it gets on the highway, it would have to meet the law, even though your insured can get by in a lot of cases by not really licensing. States differ on what must be licensed or subject to financial responsibility equipment, particularly certain special items like farm equipment. Make sure the GL policy to protect the insured when autos involved in the accident is mobile equipment and not an auto. Best at time of claim, both coverage with the same carrier. If you use a symbol any auto, and you have no GL, there's no problem, except maybe a premium, because any auto covers any auto. But if you have a vehicle, if you have a policy that requires specified autos only, then the auto must be concerned. There was symbol 19 that would cover this for any auto that's mobile equipment licensed for the road. So you would also could add that symbol, which would be the same wording that you have in 1. So make sure the vehicles are a covered auto, and make sure the GL carrier and the auto liability carrier have the same definitions, and hopefully with the same carrier. So the concern is not is there coverage, but the concern is what loss line to charge it to. The second paragraph was added somewhere around 2000, and this is the cleanup. This is the response to pollution. This is covered pollution costs or expenses. This concern here is, again, it's going to be bodily injury property damage caused by a covered auto. We're going to look at the concerned pollution when we get to the exclusion of the direct damage, which is an exclusion later in section the third hour we're going to do, and we'll go in more depth about this. Duty to defend. We have the right and duty to defend any suit asking for such damages or covered pollution cost expense, meaning if the suit has any part of that, then we have to defend. We don't have to defend any suit of bodily injury property damage not covered by the coverage form. So if it's mobile equipment, then we don't have to defend. If it's auto, that we do, but if it's gray, that we might have to defend until we prove that it's mobile equipment. In the cases of the symbols, if it's an auto that's not scheduled on a policy, then we would not have to defend. However, we don't know that going in, so we might have to defend for a period of time until we determine is it a covered auto. Because if you remember, it could still be a covered auto for newly acquired, could be a covered auto for temporary substitute, could be a covered auto for a hired car, depending on the way the insured is using that non-owned auto. So that would be a concern you have. So we'd have a duty to defend until we can resolve the coverage question. We may investigate and settle any claims, meaning that the insured does not have the rights to determine settlement or not. That's up to the insurance carrier. A lot of times our insurance asks, why are you paying? We're not liable, we shouldn't pay. Well, there's an economic consideration there, because in those cases the insurance company makes a business decision to cut their cost off, meaning their legal fees off, and get out of the case. When they do that, they'll have to get settlements from everybody, but that's when the duty to defend ends, when it's exhausted by payment or judgment, by payment of a judgment or settlement. A judgment is when the court says, the judge says, the jury says you owe X dollars of damage, and the insurance company strokes the check. Settlement is when the parties involved in the case, meaning your insured and their insurance carrier, resolves the damages done without going to court, either mediation or settlement or a arbitration, and then that check is paid. We have to defend until those items are paid. So the insurance carrier has a duty to provide defense to the insured for any suit. Typically that's broader than the payment, meaning that that part of the suit might or might not involve in coverage, or like we mentioned, the auto might not be defined there, so there's no coverage, so we might not pay anything, but we might have to defend until we prove there's no coverage. So the duty of payment of the limits. A lot of times we know you have spent the dollars day one, but unless the other side accepts the settlement, and why they wouldn't accept the settlement even though you have policy limits exposed, is because they're going after the assets of the insured. So even though you have $1 million and your carrier is willing to render the $1 million, if there's a lot of damage done, the plaintiffs might say, whoa, I'm not going to accept that because I'm still going to sue the insured who owns the vehicles because I can get something out of them over and above the policy limits. So we'll still have to, the insurance carrier still has a duty to defend until they're able to check, and that check's accepted by the plaintiffs. So these are things you would work out with your insured. This is also what's important, or some exposures for very low limit policies. You a lot of times have a defense that's over and above, cost over and above what might have to be paid. I was in a horrendous case involving a large motor carrier where the $1 million we knew they spent day one. However, because of all the circumstances, they ended up spending about $6 million defending it because they couldn't get out of it earlier. lower limit policies, you have this concern all the time. So who's the policy going to protect? Who is an insured? The entity, the you listed in the deck, and others who qualify under the who's insured provision. This is the who's insured provision. The followings are insured. You for any covered auto. Again, you is the entity on the deck sheet. Covered autos must meet the definition of symbols. Anyone else, while using with the you, the business's permission, a covered auto, meaning again symbols, that the business owns, hires, or borrows, except for, again, take coverage away from 5. Now clearly understand, the insured is still covered, the business, but not these 5 situations. The owner or anyone else from whom you hire or borrow a covered auto, the owner itself. So what we have is our insureds could have an employee. Our insureds could, could have any auto, and they could have a contractor. Let's say our insured's a contractor. They're having someone bring fill dirt to the job site. They get named in the suit because of their relationship, having the fill dirt bought there. The insured's covered because of the any auto or non-auto, or could be hired depending on the arrangement the insured has for those autos, but the owner of the vehicle is not. This exception does not apply to trailers, though, because the trailer owner would be covered. 2 is your employees. We don't cover any employees. This is why it's a concern that if you have a corporation and the entities own the vehicle personally, the owner of the entity owns the vehicle personally, they need to be scheduled. We need to add an endorsement we'll look at in a minute to convert it from a non-owned auto to an owned auto, getting back to the scheduling of the vehicles in item 3, which is owned autos only. The employees are not covered. Someone using the covered auto while he or she is working the business of selling, servicing, repairing, parking, or storing autos, unless that's the business yourself. Here again, when you take your car into a dealership, into a repair shop, you give them permission to test drive that car. They won't be a permissive user. They have to have their own coverage. Now, we'll still cover our insured if they get named in the suit. We just won't cover the garage that's using it. Loading and unloading, we'll have to look at those later as we look at GL. So anyone other than your customer partners, members, you are a limited liability company, lessor, borrower, employees, while moving property to and from the auto. If our insureds are doing it, it's covered. But if someone else is doing it, we're not going to protect them. So the insured hires someone to remove vehicles, flatbed, for example, that crane that we talked about, again, a gray area between GL and auto. We won't cover them. And the 5th one is partners. We treat them just like employees. Partners for personally owned vehicles. The partner will not be covered. The partnership will still be there. So when we look at here under B, anyone else while using with your permission, anyone else can include an employee, independent contractor, anyone else that you say, here, you can use my vehicle. It could be the power unit or the trailer, which we'll talk about some later. As long as it's a covered auto that the business owns, hires, or borrows. But we don't cover the owners of those autos under 1, 2, and 5. We just covered our insured. We don't cover garage that our insured gives permission to test drive the vehicle. And we don't cover anyone loading and unloading our units that are not our employees. That's our partners or members of the business. So those are the things. We also grant one other group insured status, and that's under C. Anyone liable for the conduct of insured described above, but only to the extent of that liability. That's when your insured would be held vicariously. Someone could be held vicariously liable for your insured's actions. In other words, they get named in the suit not because of their negligence, but because of the negligence of the insured. That's called being vicariously liable. So let's look at this and divide it up a little bit and review it in a little more depth. The policy will respond if an entity that meets the definition of insured is involved in the accident caused by a covered auto. Insured is the you listed in the item of the deck and who meets the definition of the who's insured provision. You is the name on the deck sheet. Anyone else who has permission from the U. Again, employee, driver, independent contractor, anyone who has permission to use that vehicle, it would be a covered auto as long as the insured owns, as long as it's covered, would be protected on the policy as long as it's covered auto and the insured owns, borrows, and gives permission for that person to use it. But not the owners. So if we have a situation where we cover an independent contractor and the trucking entity, that would be under one, or we cover the employees' vehicles on our policy, particularly the owners of the corporation who own them personally, the LLC who owns them personally, we cover them on the policy. Or 5, we have a partnership, and the name insured on the deck sheet is the partnership, not the individual partners, and they own the vehicles personally. They're not insured. We're going to talk in a minute how to cover the ones in 1, 2, and 5. We do that by endorsements to make them a covered auto where appropriate, but we'll go through that in detail. So the one could be not only someone doing business with you, but that's also where you would find leasing companies. How often does your insured have a long-term finance lease? They go out and rent a vehicle. They lease a vehicle. The leasing companies are not covered. The owner of the vehicle is not covered. Again, we know what an employee is, and we know what a partner is. But let's look at a minute here. The insured and permissive user will be protected, but not the owners of the non-owned covered auto unless an endorsement is added. Consideration: find out who owns the autos, that is the covered auto, schedule item 3, or the insured will protect. If they're owned by other than the you got to add endorsements, which we'll go through yet in this hour. Do not list the owners on item 1 of the deck of the vehicle, just the owner or the owners of the legal entity. You add by endorsement. We'll review those endorsements here in a few minutes. So the one thing that we have not addressed here is that plus, the bottom. Who else will make it insured? Anyone liable for the conduct of insured described above, but only to the extent of that liability. Folks, this is the insured's customers and owners of the legal entity is the insured. Anyone who's held vicariously liable for actions of the insured, meaning anyone who qualifies under A and B, will be an insured. This is when they're held vicariously liable. This is blanket additional insured. Let me repeat again. That extends coverage to all of your insured customers and to the owners of the legal entities without naming them on the deck sheet. Because the reason the customer is named in the suit is not because of their negligence, but because of the negligence of the vehicle that has their load on it that's doing business or being providing services to them. They're being held liable not because they're the negligent party, but because of the negligence of the driver of the vehicle, who's a tortfeasor. And so therefore, since they're being held liable vicariously for the actions of the driver, the person who they allowed to haul the load, they would be covered under the policy without being named. It's blanket disinsured. The same thing for legal entities. If I own a corporation, I'm going to be held legally liable for actions of the corporation because I own it, not for my own actions. If I'm driving a vehicle, I'd be covered under permissive user, but I'm not going to be covered for the actions of the my own actions other than being driving, but I'm being named in the suit because I own it. I'm being held vicariously liable for the actions of the business I own. So this is blanket addition insured, addresses customers, addresses owners of the legal entity. So how often do you get a question to add a customer of your insured as additional insured? Think about that. All the time. In fact, the first use of the policy beyond the motor carriers industry, where you have to file financial responsibility so they can complete their operation registration, where you have the 91Xs of the Form Es and the forms that we'll talk about later in section 4 or hour 4 of this. Once you have that in place, then the insured's going to ask you, I can't pick up the load, I can't do work for this person, I can't deliver these goods unless I send them a certificate of insurance reflecting I have coverage and adding them as additional insured. So the insured wants to add others as additional insured on their policy because of doing business with them. and is at the requirement of the customer. In other words, you cannot do business with them, cannot haul for them, you cannot get paid until the customer of the motor carrier gets a stiff insurance reflecting coverage, and that they are also additionally insured on the policy of the motor carrier who hauls the load for them. And so that request, and we have that all the time, and I'm sure you face that on a regular basis. There is nothing we can add to give the customer any more protection for the use of the autos owned and operated by our insured without picking up some of the customer's liability. All the protection needed is already there. No additional coverage can be provided to the customer of the owner of the auto. Just issue a specific insurance if you have permission as an authorized provider of this by putting on the comment section, by virtue of provision C of the who's insured provision of the above policy, the customer is additionally insured. There's really no difference in doing this than naming, showing the limits of what's a covered auto. They're already there. So what we have here is the vehicle is running down the highway. The vehicle is hauling their customer's good. Most often this would be for hire, or they delivering things to a job site, delivering things to a manufacturer, delivering things to a warehouse, taking or to a distributor. When the auto crash happens, it's a covered auto. The driver's a tortfeasor. They're the negligent party. They're going to be named in the suit. The owner of the vehicle, the business, will be named in the suit. And the customers could be named in the suit because of the actions of the driver. Not the customer's actions, but actions of the driver. That's be called vicariously liable. So all three get named in the suit. What I'm saying here is that reading the previous paragraphs, anyone who qualifies as an insured, and the customer now is an insured when they're held vicariously liable for the actions of the driver or the actions of your insured for doing business with that customer when they get in the named suit. They are insured, so therefore we owe them defense and we owe them a payment. And since they're insured, we would have to release them if a settlement and include the customer's name in the settlement. So this is blanket additional insured. It's already there. There's no other endorsement you can add to give them any more coverage. However, you do have some insureds who have customers with low self-images, and they say, I want to see an endorsement. I don't understand all this stuff. So ISO has an endorsement called the Designated Insured Endorsement, CA 2048. This is the endorsement. I'm going to look at that fine print here in more detail in a minute, but I just want to point out here, Designated Insured for covered auto liability coverage. I have read many of the additional insured endorsements that other carriers have who have modified their own. They have changed the title, and I've seen some that say additional insured or wording like that, or again versus the designated insured because the customers like the word additional, but nobody changes the wording that is important here, and that's that small paragraph you can't read that we have reproduced here. What the coverage is being extended under this to the name we list here. Any person or organization shown in the schedule, meaning who we list here, isn't insured for the covered auto liability coverage, but only to the extent that person or organization qualifies as insured under the who's insured provision contained in paragraph A1 of section 2. Covered auto liability covers the business auto motor carriers form, and section D2 of covered autos coverage of the auto dealer coverage form. In other words, all the coverage have is going back to what we had read in the previous paragraph, and that is anyone liable for the conduct of insured above, but only to the extent of that liability. This is the coverage that we have here, period. So really, so you understand, when you add CA 2048 to the policy, all you're doing is one thing. If the customer do not believe they're an anyone, we'll put in writing, yes, customer, we agree, customer of our insured, we agree you are an anyone. It does nothing else. It adds no coverage, it adds no notice, It picks up no liability coverage for the insured. It's just when they're held vicariously liable. It only clears up the mystery, are you an anyone? So if the customer's doubt of your insurance that they're an anyone, then we'll put in writing, yeah, customer, we'll agree you're anyone. You're an anyone. They already have the coverage there. This is clearly misunderstood. I know some insurance carriers who charge for this. $150, $200, $300. I was at one time in a large discussion on behalf of one of my clients who had a carrier wanted to charge me $750 for this endorsement. And I said, why? There's no coverage there. Why are you charging me for this? And they finally reduced it down to $100. And the answer to that is why, when I kept asking why, well, it cost us that much to issue the endorsement. I'm saying, well, you need to get something cheaper to do that. I can understand that, but it's not for coverage. Anytime we pay for something, we think there's coverage there, but the policy already builds that in. This, again, that's blanket addition insured by virtue of that wording in the provision C in the business auto policy, who makes anyone an insured who's held vicariously liable for the actions of our insureds and or their drivers, their permissive user. So the CA 201 designated insured endorsement, excuse me, CA 2048, the designated insured endorsement, or any other additional insured endorsement I've seen contains this wording in it, which gives no more coverage to the insured customer that's already built in the policies. This is just to make the customer happy by seeing their name on an endorsement. And again, the only thing it does is clear it up if they have a question, if they're anyone. Again, I recommend the adding of the wording in the certificate of insurance is simpler than adding these endorsements because you have no additional coverage. But if you also want to talk about here, what do you want to be a name insured line on item 1 as insured because of their ownership of the legal entity. We talked about in hour 1 that we do not want to include the owners of the legal entity on the name insured line. Obviously, if I'm a proprietor, if you're insured as an individual proprietor, Tommy Ruke doing business as Tommy's Trucking, yes, you have to. But other than that, you do not name the members of the partnership. You don't name the members or the managers of an LLC. You don't name the stockholders who own a corporation or the officers or directors, executive officer of the corporation on the name insured line. I said that they already have coverage. Here's why they have coverage. Because the reason that they're going to be named the suit for owning the legal entity is because they're being held vicariously liable for the legal entity they own. So this is also where all owners of LLCs, corporations, partnerships are already covered without naming them on the name insured line. This is where all managers, executive officers, directors are already covered without naming them on the name insured line because of this wording here. So again, by naming them, you give them no additional coverage than they already have. You might extend for owning the legal entity. You might have a problem, though, for picking up some personal activities, and we went through, and we discussed that when we discussed symbol. Again, anyone liable for the conduct of insured described above, but only to the extent of that liability. That's vicarious liability. That addresses liability for the customer being held legally liable for the actions of the insured. That's called vicarious liability, or for the owners of the legal entity being held liable because they own the legal entity. But not if they own the vehicle themselves. This was the concern. If they own the auto personally, meaning the truck, the tractor, not the personal vehicle necessarily, but any vehicle that's a covered auto, and it's insured by the business auto of the business they own, or if they are or others who own the autos that's a covered auto, these owners of non-owned covered autos must be made and insured by adding endorsement, protect them from the possible being held legally liable because of their ownership of the non-owned auto. That's an auto not owned by the you, but used by the business. That's the you. These endorsements are needed because the owners of the non-owned covered autos are not automatically insured even if the auto is listed on the policy. That gets back to the exception under 1, 2, and 5. Even if the power unit autos are owned, the entity that's owned the you, meaning if the owner is a member of the LLC is a stockholder in the corporation or as a partner owns them personally, they're not covered. We have to add an endorsement. There are 4 endorsements. CA 9947, employee as lessor. That's the owner of the entity themselves. CA 201, additional insured lessor. That's long-term finance leases. Hired auto, we use that often in the trucking industry to add the owner-operators, independent contractors' vehicles to our policies. And employees as insured, this is where we have insureds who use their own personal vehicles on behalf of the legal entity. Those would be your people going getting the mail, people making sales calls. In the trucking area, it could be a mechanic with their own pickup truck. So let's look at these separately. Employee as lessor. This is to be used, in my opinion, when the owner of the legal entity owns the vehicle personally. This covers them for owning the vehicle the legal entity is using and insuring. They're already covered for owning the legal entity with the previous wording, but not for owning the vehicle. This then converts this non-owned auto, because it's owned by the owner of the corporation, the owner of the partner, or a member of the LLC, from a non-owned auto to an owned auto, which makes coverage primary, and it covers them for owning the vehicle themselves. We get hung up sometimes in the lessor wording. No, in my opinion, there does not have to be a written agreement or written lease. Why? Because there's no difference in enforcement between a written lease and a verbal lease, except for the parties remembering what's in the lease. I promise you I would not forget I agreed to hold myself harmless when I insured vehicle owned personally by a business I own personally. That's not a question here. So this needs to be added. Going back again, who owns the vehicle? If they say it's I, then it's I, the small business, meaning it's titled in the name of the corporation, the LLC, or the partnership, or I as a partner, a member, or the stockholder, the owner of the corporation. This is where we add this endorsement if it's that second entity. Lessor. This is long-term finance leases. This is where your insured signs an agreement that says I'll lease this vehicle from, could be PACCAR, it could be GMAC, it could be some finance company, it could be a bank, where they have a long-term finance lease. Hertz and Ryder typically don't have, Ryder does, but Hertz or Avis typically does not have long-term leases. It's a long-term lease. This is with a leasing company and loss payee. The leasing company requires the insured to add them as additional insured on the policy and also give them protection as because they own the vehicle's loss payee and notice of cancellation. So this is when we use this. And this is the fine print. So I'm going to look at the provisions in the fine print that have a relevance here. Coverage. Any leased auto designed or described in the schedule will be considered a covered auto you own, meaning the covered auto now is primary. For a leased auto described or the designated described in the schedule, meaning the schedule of this endorsement, the who's insured provision under the covered auto liability coverage is changed to include as an insured the lessor named in the schedule. So the leasing company is now an insured. That's the lessor. That's who owns it. But this was added in 2004. However, the lessor is insured only for the bodily injury or property injury resulting from the acts of omission by you, any of your employees or agents, or anyone except the lessor or employer agent. So what we are giving the leasing company is nothing more than what we already give them in that vicarious wording, because we're not picking up the leasing company's negligence. All we're picking up is when the leasing company is being held vicariously liable for the negligence of the lessee. That's the person who's operating the vehicle, not for their ownership of the vehicle. So this is not extending much coverage here. In fact, there's a quirk here that if you're familiar with this part of this and familiar with the leasing arrangements, there's something called a Graves Amendment, G-R-A-V-E-S. A Graves Amendment is a federal law that's been upheld in all jurisdictions I'm aware of, which says a leasing company cannot be held legally liable for the actions of the lessee, the person they leased the vehicle to. So what we just named the leasing company as initially insured for, they can't be liable for. Typical wording here, but we're not extending the coverage. We're making the leasing company happy. That's occurring here. There is no two provisions here that is. First is the cancellation. There is a third cancellation provision. So we have to send notice of cancellation to the leasing company. There are other national insured endorsements we don't have to, but here we have to. So if it's canceled, we must nail the cancellation, and the cancellation ends this agreement. The lessor or leasing company is not liable for premium. The other one here is leased auto. Remember I said that the newly acquired does not pertain to any vehicle that the insured does not own. But if they lease the vehicle and we add CA201 and that leasing company gives the insured a temporary substitute, a replacement unit, or an additional unit to meet seasonal needs, then that vehicle that's not scheduled in the policy, that is a temporary substitute, replacement unit, or an extra unit that's needed for seasonal is a covered auto under the form. So this is how you get the temporary substitute and newly acquired handled. A lot of times a leasing company will give you insured another vehicle while they maintain the one or go put the one they have in maintenance or one gets wrecked. Those other additional vehicles are already covered as long as they're leased from the same leasing company. So CA201 is to keep the leasing company happy. For liability purposes, it's not extending the leasing company any additional coverage than what's not already in the policy, and actually the coverage we're extending they can't be held legally liable for. We do have to send them notice of cancellation. More important in the areas of lost pay, so the check's named here. But we do cover the temporary substitute and additional vehicles from that same leasing company automatically. Hired auto, again, these are autos that are used for independent contractors agreements. The provisions here is the following is added while covered auto described in the schedule. It's scheduled in the schedule. It's also a covered auto because it's scheduled on the policy. It's rented or leased to you. These are owner-operator agreements, so it must be a lease and being used by you. Then that owner is an insured. So CA 9916 is used to cover owner-operators, independent contractors that we insure on our business auto policies for our insurers using of those. Again, usually specialize in the trucking industry. A lot of you all are involved in that as a motor carrier, insuring the motor carrier. This is how you do it. When you schedule an owner-operator's vehicle in the policy, what you would want to do, you would add 9916 to protect the owner. You schedule a policy so you're getting a premium for it. We want to know about it because we'll know who the owner is, typically that driver. We'll cover the owner as long as the vehicle is still leased to your insured and is being used in the business of your insured. The third one is employees as insured. This is unique in this area here because when the loss happens and your mechanic is using their personal pickup truck and gets in a crash because they're on the mission of the insured, then the insured could be named in here. That's the mission of the business they are doing maintenance work. And so then it can be named, the business can be named the suit because of the actions of this employee using the employee's personal vehicle for the benefit of the business. Again, mechanics or someone making a sales call or someone going down to pick up lunch, pick up supplies, or go to the mail. This way, the employee's personal vehicle policy would address the crash. The personal vehicle policy would cover the business because of being that vicarious wording, even the personal auto policy. But the insured, the employee themselves are not covered. And so this is an endorsement that CA 9933 that covers the employee for the employee's personal use of vehicle over and above their own personal coverage. The premium here is very low as a concern adding this because most of the time the lawyers will say, well, we're going to have to defend that employee anyway. They're driving the truck, they're causing the accident, we still got our insured's name in it, so we have to defend the case. How will it sound when you would say, okay, insured, you had a crash, excuse me, employee of the insured, you had a crash, please turn this into your own personal auto policy and make sure they defend my insured. And by the way, if we can't settle it here, you got no coverage in our policy, but will you please be a witness and help us lessen the cost of it? It wouldn't happen. So if your insureds are using or allowing employees to use their personal vehicles for the business, sales reps, mechanics, running errands, real estate, churches, those kind of things, then you want to endorsement, but you also would want to have a level of insurance that you would require the employee to have, 300,000 or whatever you're comfortable with. That's where the first coverage here. And then they would add this. This would be a benefit to the employee in this situation. But that would be how that would be used. It's not primary coverage, it's excess of the coverage on the employee's own policy covering their own vehicle. So conclusion, coverage. It's the insured, the legal entity. That's the business whose assets are exposed because of the autos that they have. We want to make sure it's a covered auto. That goes back to symbols. We'll pay BI and PD, covered inclusion cost and expense, as long as the insured is named or someone qualifies insured is named in the claim and it's caused by covered auto. We do have a duty to defend as long as there is any part of the suit is until a payment can be made by the judgment that we pay or a settlement. But if autos are not mobile equipment that's licensed for the road, then that's GL. So we have to make sure the auto carrier and the GL carrier are on sync concerning those. But the who's insured, we cover the you, we cover the listed user, but not the owners of the non-owned covered auto. We have to add an endorsement, CA 9947, 201, 9916, or CA 9933 to make the owners of covered. 47, 01, and 16 makes the auto an owned auto, which makes coverage primary. CA 9933 does not. CA 933 covers the employee, but only in excess of the coverage they have on their personal policy. Also, anyone held liable for the above. That's blanket additional insured. That's the customer's owner legal entity. We can add the designated insured endorsement to make the customer happy, but it extends no coverage. All it does is clarify about who is or are they anyone. We'll look forward to having you participate in Section 3 in the third hour. Thank you for your time.